Great, thanks. Welcome, everyone. It's so good to see people. Uh, we have, the wonderful thing about Zoom is that require registration is one gets a list often of how many people will be there. I don't have that list, so I don't know. People seem to still be coming in. Let's give it another minute or two before we really get started. Legal, so.
Good morning.
Good morning.
Good morning, everyone.
This is our wonderful legal Q&A session. I'm sorry, I lost my link to the notes document, so I'm not gonna have the formal introduction to give to Meredith.
I can introduce myself. I know who I am most of the time.
That's good. Why don't let's see. So I think welcome everyone. I'm sorry I'm a little flustered. I had trouble getting into the room, and so welcome everyone. We have this is a wonderful opportunity as part of this course to get to ask questions to some of the most amazing legal minds and who are wonderfully friendly and helpful and non-scary. It is our privilege to talk to Meredith Jacob, who is an amazing legal scholar and a speaker and communicator. And I think the plan will be that we have a document which has questions that people have been putting in. But I think it's also people who've been able to be here. Have we started the recording, by the way?
Yep.
Rebecca?
Good to go.
Yes.
Yes.
Good. Okay. Good. So just to warn people, everyone, we are recording, but so we have a document with questions, and but we'd like to prioritize anyone who's here as well. So I think maybe I will just hand it over to Meredith, please, to give a little introduction. By the way, I'm Jonathan. I'm one of the facilitators. I think I see other facilitators. I think I see Suzanne and Rebecca are facilitators who are here. Maybe Meredith, you could introduce yourself quickly, and
Sure.
then if you want to take questions that you like out of the question document, and also people who have other questions or follow-ups, please don't hesitate to put things into the chat, and we can go from there and maybe continue live if it's more convenient.
Perfect. Thank you, Jonathan. Good morning, everyone. Thanks for taking the time to join us, whether it's morning or evening, wherever you are. I know this is sort of ranges from late afternoon to very early morning for different folks. My name is Meredith Jacob, and I work at American University Washington College of Law in their program on information justice and intellectual property, which is their public interest IP program. And we have sort of two parallel purposes in this webinar. One of them, which is sort of built into the structure of it, is talking about how to give people accurate and meaningful legal information without giving them legal advice. So I cannot give any of you on this call legal advice because I am not your lawyer and we don't have a client relationship. And you all should mostly, I think, try to not give people legal advice because you are also not their lawyers. And it's sort of easy to say, like, well, I'm not a lawyer. No one thinks I'm giving legal advice, but it's important to sort of keep one step back of that. This certificate program often has a lot of folks who are experts in their systems and their institutions about this stuff. But you want to make sure that when people come to you, that you are helping them sort of think through the answers to their own questions and provide them with sort of information and education, and not sort of doing the, yes, you can do that, no, you can do that, like the sort of giving fact-specific legal advice. And so as we go through these questions, I will try to sort of model that, which is to say, to give you guys answers that are meaningful, that provide guidance, but still at some point provide the information and the structure for you all to make individualized decisions as you go through your work. Does that make sense to folks? Any questions in this moment about what the boundary is between giving people information and training and assistance versus actually giving them legal advice? Okay. As Jonathan said,
Can I ask
yeah, please.
Let me, can you maybe give us a suggestion of, like, what if you're talking to a colleague and they say something which is just clearly really bad news, and you were not supposed to give legal advice, but I had a colleague at my former institution who said, well, I bought a book, and since I own it, I've copied the half of it and I've distributed copies to my class. And like, I really think that's, what do you say at that point?
I think you can certainly say, like, what I would say in that situation is, I'd say, well, generally, I think copyright law says you can't do that, so unless you have some specific thing like fair use, or the book is in the public domain, or you bought a separate license, I would be really concerned that that might be copyright infringement. And, you might want to go think about that, or look at this thing, or here's this resource that talks about that. I don't think, obviously, I think you can say to people, I think you might have a problem. And the flip side is true. Someone might say, I really want to explain to students what I mean when I'm talking about first person versus third person narration, but I can't copy anything out of these books because that's definitely copyright infringement. And you can be like, well, there are actually situations in which, fair use would allow you to do that. Here's a document to look at that. I think that might be possible, right? And in both of those, what you're not saying is, okay, you've told me your facts. I'm definitely telling you this is what the law will say. Because that's the thing that is giving legal advice, which is giving fact-specific sort of determinations of this is the law, this is legal, this is not. And the other thing about this is, in many situations, as we'll talk about later, questions are going to be a lot about the sort of specifics of the activity they're doing. And so they are the better person to make that determination, right? They're the person who knows the sort of whole scope and whatever of the project. And sort of whatever information you're getting is going to be sort of limited. And that's one of the reasons, even as a lawyer, for example, you don't want to give sort of hot takes legal advice, because there's no way that you've done the sort of deep, do I know all the pieces? Have I thought about all the interactions? We very regularly are like, we can't give hot take legal advice. And then we say, but, and we give you like our hot take, but still it's the big picture. So let's look at some of these questions in the document. And again, I will say, these questions are submitted across the different cohorts in the certificate. So I don't want to answer questions here that no one in this section has asked, and miss the questions that they have. So even if you put your question in the document, if you want to drop it into chat, just to let me know that you're here and that you would be specifically interested in that, that can help me focus my time a little bit. So there's some questions in here about attribution and about share alike and share alike compatibility. And there's some questions about updating the license, questions about sort of blanket giving of the license. I'm just looking through to sort of see if we can sort of organize those by topic. Okay. So the first one,
there's also a question in the comment about in the chat about something about AI, but maybe you'll get to that later.
Perfect. So they want to start with these questions about the sort of formal uses of the license. So questions about like how attribution works. And so there's a question here that says, what do you do when you're linking to a work that was formerly up there, but the link is dead and you don't know how to sort of attribute it because linking is part of it? And so one thing you can often do when you have a question about like that in the license is to make sure you read the legal deed, because there are often sort of nuances of what that means in the legal deed that aren't in the human readable version of the license. So if you look in the legal code for the CC BY license, which I'm going to drop in the chat here, the CC BY license, the requirement says to retain the following, the license. You need to retain these if it is supplied by the licensor, which is the identification of the creator, a copyright notice, a notice that refers to this license, a notice that refers to the disclaimer of warranties, and the URL. So the URL, if possible. And so for all of these things, if you can't do it, there is all this sort of language in there that says, if possible. There are things that are not sort of qualified that way, but the URL is that way. And so what I would say generally is, to the extent that you know the thing is openly licensed and you provide the materials that you have gotten to the best of your ability, you can add other information, but I don't think that you would ever be like, oh, this was up on the internet, CC BY, but now I can't link to it, so I can't share it. I think you can just say previously available at. I don't even think you have to say that. You could do so, I think, if you think it's useful to someone else. So like, if all you have is a URL to like a Flickr page that just that fails, right? You get like a 404, it's like this page no longer exists. That's not really useful to anybody. If you had a link that was useful to someone, maybe into understanding where it came from, you could do that. But I think for the attribution, to attribute the information you have. Sometimes we have work that is CC licensed that does not have a stated author or title. In a similar way, like not all photographs have titles. So you just provide the information you have. The idea, like, you have to provide an attribution, and the evaluation is going to be, did you provide the attribution that was most meaningful and aligned to the license terms as possible? And the other part of it, that's in the license code, is to say that you shouldn't remove information that is there, right? One of the things we often see is that people might put additional information in that attribute as space. So one thing you often see is, this work is by Meredith Jacob, supported from a grant by the Hewlett Foundation. Sometimes funders want to be listed in that. And generally, when possible, you should include all of that stuff in that original attribution, or the available at, right? If someone's doing a bunch of work to make, for example, OER available on their website, if they say, you know, this work, this textbook, whatever, by these authors is available at this link, you should keep that link in there and that information. But to the extent that something is missing and you can't find it, you should just do the best you can and go forward. I don't think that's a sort of controversial problem. And so there are some questions about share alike and interoperability. So the first one here is, what's the relationship between copyright and share alike license? If you translate something that is under a CC BY share alike license, are you then obligated to issue the translation under that license? Isn't the translation considered an original work, in which case the author of the translation has copyright to it and should be able to assign whatever license they see fit? If not, please confirm that owner of the original work can authorize a third party via a separate license to issue under a translation under more or less restrictive conditions. So this is complicated. The answer to, generally, I think the answer to those questions may be no, but I'll explain that. When you're producing a work in translation, there are two separate copyrighted works, right? There's the work, say, if you're translating a work from French to English, the author of the first work has a copyright to that work in the original French. When you produce a translation of that work, you are going to be making a derivative of that original work. And without a license, that derivative is going to be an infringing work. So it is a new work in the sense that you, as the translator, have ownership over the English version, but that work is infringing the French version unless you get a license to do that translation. And so here, if the original work is CC by SA, the license that gives you permission to do that translation is that CC by SA license. And you meet your half of the agreement in that license by issuing your translation under that CC by SA work, SA license, right? So the work would be infringing. To make it not infringing, you license it to meet the terms of the license. And normally, we sort of generally say, if you put something out under a CC license, you as the copyright owner can also do separate parallel licensing under like a commercial license or a more restrictive license. But in this case, the problem with that is that you now do not have a license that gives you the right to relicense the sort of original reference thing under that restrictive license. Because the only way you got permission to do it was that you said, I will also put it out under that license. So you have agreed to the SA license as the terms of getting to make that copy, that derivative work. So here, if you wanted to say, I'll put one copy out under CC by SA, if you wanted to put a copy out that was also commercially published, all rights reserved, you'd have to go back to the original French author and get permission from them or a license from them to do that. So you can have an original, like it would have a new copyrighted work that you are the owner of, but that still infringes or is a derivative work on something else that you need to get permission before you can sell or distribute that. Does that make sense? It's a sort of two-step problem. I don't know if
May I have clarification on that
sure.
or variation on that? Let's say that the original French author had actually done a CC BY license.
Yes.
And I created an English translation. Could I sell my English translation because I have the copyright on the translation part of it, although I will still have to credit that it's based on an original work which anybody can use as long as they go back to the French.
So you would just have to meet the terms of that CC BY license, which is attribution.
Yes. Okay.
So you can absolutely sell things that are based on CC BY things.
Thank you.
So you would just need to meet the terms of the license, and you would have to make sure that your publisher understands that they need to meet the terms of the license.
Good point. Thank you.
But 100%, you could do it. And the other thing I just said is, and this is my perspective, not the official perspective of Creative Commons Inc. and its subsidiaries, but I think often people use more restrictive licenses because they are concerned about different types of bad actors. And so if you are looking at something and you think a more restrictive license type prevents you from doing the thing that you want to do, if what you're doing is something that you think is still sort of productive and useful, but you just have this like technical incompatibility problem, I would really encourage you to just reach out to the original author if you possibly can and say, hey, are you willing to relicense this? Or, hey, are you willing to give me, written permission to do this? Because I think sometimes we see like two people, one who might have picked like a CC by NC SA license and one who picked like a CC by NC license, and you're having trouble figuring out your remix. And the truth is neither of those people has some like deep philosophical commitment to that license. It's just the one they picked. And so if you go back to them and say, well, hey, I really want to create this awesome OER, or I want to translate your work, and it's going to be sold because that's the way we run our university press or whatever, I would just encourage asking, right? As a separate issue, especially where you're like, the person has already openly licensed this. It is a reason separately that I encourage folks, unless you have a pretty clear reason not to use the CC BY license, because I think the other licenses can do more to inhibit people who are being super careful about sort of charting the licenses than they do to actually prevent bad actors. There are a couple other share-alike questions in here that I wanted to answer before we moved on. Here's one that says, if some work is made available under CC, oh, the second one is sort of the same thing. So the question about whether you can make something under a CC BY license and then hold it confidential, it's sort of complicated. There's a term in the share alike licenses in the current version, I think. Let me look at it real quick. That really basically, so again, this is a chance where this is not necessarily clear in the human readable text, and you have to dig into the code. So if you have a question about what the licenses do, like, can I do this technical thing? I would encourage you to dig into the code, like the long legal version, not just the original front text. So here, let's look at this real quick. So in one version of the CC licenses, there was a discussion about whether or not so the question here is, when you read the terms, it says if you share the licensed material, right? And so there's this term also, it says share like, in addition to the terms above, which are attribution, if you share adapted material. And so basically what that says is, I think the licenses are suggest, but maybe do not comprehensively state, but I think there's a strong argument that they can be read this way or should be read this way, which is to say that if you do stuff with CC licensed material and you do not reshare it, that you do not actually trigger all of those license terms, right? So that, like, if you had a CC by, NC essay material and you just had it and did stuff, you like made copies and you rearranged it, but you didn't share those copies like outside of your own sort of control, that share alike term isn't triggered. People also talk about this with like the no derivatives term. Like, if you download and use a no derivatives thing and you create a derivative for your like own personal study or use, that you aren't really violating that term, because it's really about not sharing derivative works, not about not creating them in your own private use. I don't think we have like clear absolute guidance on that, but in that private context, it would really come down to me is, from both a law and a risk standpoint, do you need that license at all? So if you're creating something and just to pick like a totally extreme example, if someone put out like a journaling or like a cognitive behavioral therapy template, and they put it out under a CC by essay license, and you were filling out that template and using it and changing the parts so it worked well for you, and you were using it in your own sort of private journaling or, self-improvement work, no one would suggest that you had to share out those copies, right? They'd be like, no, you're using it for this private purpose in your house. You're not really meeting the terms of the license. I think this question really gets blurry. Like, and I think the answer is no if you start using it in like a, school-wide LMS. And I think the question really is like, where do you cross that line to the point that you are sharing the work back, right? And I think the answer is somewhere more than you in your house alone using it for private purposes, or even using it for professional purposes. If you were a therapist and you were using worksheets that were created in a context for that, I would really say like, no, like that share alike term gets triggered if you like republish those. It doesn't get triggered if you use it in your work in the office and you store it in a file, in a thing. But I think it really comes with sharing it with other people, and sort of when that other people, it's not one. I can think of a lot of contexts in which I would definitely argue it's not two. And it's definitely if you put it on the internet. And so part of this work is that these licenses cannot contemplate every case like this. And I would talk it through, but like that's how you think about it. Does that answer that question? Is the person who asked that online? they're not. I hope that's useful. There's some questions about license compatibility in here. I'm not going to sort of spend too much time answering those because the answer is it's very complicated. You have to read the terms of each license. There was for a while license compatibility chart that was on the CC website. I don't know if it's still there. I'll work with the facilitators and try to find that, because it's just, you have to sort of look at the terms. It's one of the reasons that we deeply, deeply beg and plead for people to use the existing standard licenses and not create their own. And then also to basically try to be like, okay, what is the most common license in the ecosystem in which I work? Like if you are writing software, use a software license. If you are writing human readable content, use a CC license, because it's really complicated. And so I can't just sort of look at those quickly and give you an answer there, unfortunately. But I will look for that license compatibility chart and see if it's still online. And to the facilitators, Kat Walsh may be a person who knows if that's still up and still available. So there's some questions about remix and share alike and cross-version compatibility. So for the share alike and remix, one of the questions is what you are making sort of a collection of things, or is it really a remix? And there's no like single clear legal answer to this, but I think the pragmatic answer sort of is very I would sort of just direct, which is, can you easily and reasonably attribute the parts separately? Does a reader or a viewer easily understand the parts separately, right? So if you have a bunch of different chapters that you've selected from different things, I think you can say, you know, this book is composed of these things, this chapter is under this license, this chapter is under that license. I think the community is generally pretty comfortable with the idea that you can have share-alike pictures in an otherwise not share-alike resource and not need the same license. So here, if someone sees a CC by as a photo in a poster, I don't think it means the whole poster needs to be licensed that way. In the same way that regularly in sort of commercial work, you have, you know, individual pieces that are under different licenses, like, you know, you have credit the photos. I think that's pretty clear in that case. And so the question would really be, can I meaningfully lay out the parts with separate licenses? Or is it gonna be like, well, different parts of this whole sort of inextricable thing are under these different licenses? That's not meaningful, right? And so I think the question really would come in and be like, would a reasonable viewer be like, okay, yes, clearly this part is under share alike. And if I use this part, I need to follow the share alike license, and this part is under whatever, and I follow that license. It's really a practical question. And that's also the question that sort of practicality, to answer Jason's question about whether or not you need to link to an archive site to provide a link, or whether you can sort of, you know, give up on search. And I don't think it's that technical a problem. You know, I think it really comes down to like, is it useful in this situation to link to that, right? Like, is it useful to other readers? Like the link needs, you know, the answer is don't take a link off if it exists. But if the link is dead, you could just leave a note that says this link is dead, also available here. I don't think you have to go and search for it. I think you can just keep the original link and note that it no longer works. Or if the link is sort of like meaningless, you can just say originally posted at Flickr, right? You don't need to. Generally, formalism is not your way out here. Doing a sort of reasonable job. So there's an interesting question here that says, could you say all works of this type are available under a CC BY license starting 2 years after their initial publication with this statement? Is that valid? I don't know if it's valid. I'd say it's not super helpful because later people would then have to do a bunch of research to find out when they were published. I think if you were going to do that, I wouldn't, I would just say, I would sort of write a narrative text that said something like, this item is, will be available under a CC BY license or is available under a CC BY license after X date. But again, there you're sort of expressing intent. And so like how well people will interpret that is sort of medium. I don't think there's anything that keeps you from doing it. I would, I'm not sure whether or not I encourage it, but I don't think there's any like obvious problem with it. Have we answered all the CC BY questions? I'm trying to figure out if there's only, if we've missed any there, but I don't want to answer everyone. So there's a question about whether CC style license can manage other intellectual property rights, such as patent or trademark. I don't know if that person who asked that is here. Generally, so one of the reasons you need CC licenses, maybe the core original reason, is that copyright attaches automatically. So if you create something that is eligible for copyright and you don't intend to get money for it and get people to come and get licenses from you, you just want them to use it, you have to affirmatively do something to do that, right? Like you have to say, I am the copyright holder, I give this to the public, because otherwise everybody has to assume that you have all rights reserved, 100% enforceable copyright. That's not true as much with other areas of intellectual property. So patents, for example, you only get a patent if you filed for a patent. So it's this long, sort of arduous process that takes, years and thousands of dollars. And so way fewer people end up with patents that they didn't ever intend to have or administer than people end up with copyrights they didn't ever have to administer, right? There are hundreds of billions of copyrighted objects out in the world. Every picture, every, medium long email, all that, all copyrighted and all copyrighted automatically. And so we specifically need the CC licenses because they get us out of that automatic, default assumption. For patents, there are a structure called patent pledges, which is it's a basically pledge not to assert. And so patent pledges can have a full range of formality from something that looks like more of a clear license grant to something that was like Tesla early on had all our patents are belong to you sort of meme based patent pledge that later became an enforceable patent pledge. The other thing with patents is that unlike copyright, a license for a patent doesn't give you clear space to operate, right? So like a cell phone has hundreds, maybe thousands of individual patented things as part of that cell phone. And just because one person has given you a license to like this specific patent doesn't mean that other patents that also affect that technology or that process aren't out there. So in copyright, because if I give you license to use my copyrighted thing, and because copyright has sort of, you can create very similar content if you have really separate authorship. And so in copyright, if I give you a license to do stuff with my copyrighted work, and you're really only working based on my thing, your chance of infringing other random stuff out there that you don't know about is basically zero, right? You have to know about something to infringe it. That is not true in patent, right? You can infringe a patent having never known it existed. And so patent pledges, while they can be useful in certain fields, don't provide you with the same freedom to operate. Trademark, again, trademark you only sort of get if you are working to establish that brand and or you register the trademark. And so again, people don't end up with trademarks by accident. So I'd say, in the pledges space, there is some space for, I think, a generally parallel theory. And I think some of the open source licenses actually talk about patent as well, open source software licenses. But I'm not sure about that. I am not an open source software license expert. But I would say the patent part, generally you don't need an open license. And to the extent that you want to share something publicly, because patenting is based on invention, you could just, like, if you wrote your article and like, here's my invention, I am sharing it, I am not patenting it. If you don't patent it, other people can use it automatically. You don't have to do a different legal thing to do that.
Meredith, at some point I found out that there is a CC public patent license, and I'm going to drop the link in the chat, but it seems that it hasn't been updated. So
yeah, people want there to be a CC patent thing. The reason that you haven't seen a lot of use, I think, of the public patent license is that the situations in which people go to all of the effort to get a patent and then later decide to share it under such broad terms is low. So, for example, there's specific term patent pledges. So there's like an open COVID patent pledge that came into being about 3 or 4 months into the start of the COVID pandemic, where companies said, hey, if you're using our patents, any of our patents across the board for COVID-19 response, then we won't sue you, right? Which is what a patent pledge is. But in fact, I think, well, and there's a question about non-commercial, but unfortunately, unlike copyright, because using patented stuff usually involves a lot of commercial steps, the truth is a non-commercial patent license doesn't let people do very much, right? And so fundamentally, I think there is this desire for an aligned patent theory, but we just haven't seen it play out. We see it in these patent pledges, and usually the patent pledges happen for a reason, right? So like the open COVID one was like a philanthropic pledge. You also see patent pledges around, so like Tesla's patent pledge was around car charging technology, where they were trying to get other people to adopt their standard, right? So usually you see patent pledges happen for like sort of more of a strategic reason. But yeah, generally I think if people aren't intending to exercise a patent, they just don't get a patent. And patents are, and this is just pragmatic, patents are mostly controlled by the General Counsel's Office of Large Companies, who are really risk averse. And so the idea of taking this piece of intellectual property that you spent tens of thousands of dollars to get and then giving it the open license, there just isn't like the incentive structure there. Whereas like tons of people have copyrighted stuff that they've created for explicitly non-commercial purposes and therefore want to share.
I mean, arguably, Meredith, I worked for a technology company in the R&D division, and they wanted us to patent every idea we had. And the idea was to kind of pee on different parts of science and technologies that other companies could then be sort of exclude. You know, they couldn't be prevented from doing work in these areas by other companies patenting things which could be argued. So it was a strategic thing, and one could imagine NGOs or governments trying to do a similar thing to strategically force things open, like maybe around COVID. So
yeah, so
serve a social purpose.
Yeah, it could. Not to go too far down the rabbit hole for patenting, but you don't need to patent something to prevent other people from patenting it, right? There's like a 1-year bar. If you publish something, then other people cannot patent your published thing. And like the company, they're doing it because it puts you in a better litigation position. I'm not saying this will never happen. I just don't think it's where. The other thing about patents is they're relatively short. So patents last basically 20 years, depending on how you count. So unlike copyrighted stuff, which is copyrighted forever past its any sort of useful, meaningful life, by the time patents issued, they're also often only valued for, valid for like 17 years, 15 years, something like that. So you don't have this sort of endless long tail of unusable stuff. There's some questions about reference. So in a CC license material, if CC license materials are being used more as reference rather than adaptations in like a typical academic work, and referenced appropriately, does fair use apply even if the created academic work is published and made online available for public consumption? And so that's a good question, I think, if I'm reading it right. So if you're writing like a traditional scholarly article and you're going to copy 2 paragraphs from a different article to say, you know, the first time this argument was set out, it was set out this way, and you have like a block quote. That's a typical thing that would be covered under fair use. And if you have the ability under fair use to do the thing, you don't need to reach the license. So in the text of the licenses, it says they don't limit any sort of national law limitations and exceptions to copyright. And so if you don't need the license, if the copyright law lets you do it, right? So if I'm operating under fair use or fair dealing or the quotation right, I don't need the license. So I just can use the work and cite it as I would in normal academic citation in like MLA or whatever. If you want to link to it, because you're like, hey, my readers might want to know this is free, you could say, you know, freely available under a CC license but there's no legal requirement to meet the attribution standard, the CC attribution standard, if you are covered under fair use. In the same way that you might need to, in an academic context, attribute ideas, right? So if you read a really great CC by journal article and you got some insights from that and you were citing those insights in your scholarly work, you would need to attribute to that article from a scholarly standpoint, right? You'd need to have that reference so that you didn't act like those person's ideas were your ideas in your scholarly writing. But you certainly don't need to attribute under the license because you've copied none of the copyrighted stuff. So we need to keep sort of 2 separate parallel things, which is how do I do attribution and citation for my doctrinal professional standards, which varies widely, right? Between like published article and textbook and email and whatever. And then separately, is my use either in the public domain, like ideas and facts, covered by a limitation and exception like quotation or fair use? And if neither of those are true and you need to meet the license terms, then you need to have that formal license statement that CC talks about. Does that answer that question for folks? So there's a question in the chat here about a question regarding US government information. So there's a question basically saying if you're using US government information that is in the public domain, which is correct, stuff published by the US government is generally in the public domain, then what you should do is attribute it to it. You should be clear in your license that that isn't under your essay license. So like say you were adapting, you have a book chapter that is under a CC by essay license. You grab 2 paragraphs from a federal government website that are in the public domain. You put those 2 paragraphs in your new thing that you publish under a CC by essay license. And you should just say in the front matter and then clearly in the text, everything in this work is under a CC by essay license. It's based off this other CC by work, except for, you know, pieces that are in the public domain or pieces that are included under fair use. And you could list them and you could mark them. And questions of how you list them and mark them are really based on like the style of the work and the type of the stuff. And whether you want to list it all in the front or list it in the front and mark it in the back, or however you do that. You just need to be clear. Some of this is under a different license or is in the public domain or is used under fair use. So we have 15 minutes. Do I know there are any questions? We can sort of go through and find ones we haven't answered, but I also wanted to see if there were questions that folks on the webinar had.
Meredith, it seems like there's a follow-up in the chat about the US federal government websites, and want to assume everything on them is in the public domain.
I mean, the answer to that is annoying. I think you should be able to assume that, but the truth is there's a lot of stuff on some US government websites that are created by contractors and therefore not necessarily in the public domain. Marking things as public domain with the public domain mark or CC0 mark is a thing that like it would be great if they did. But I think the answer is generally so the question is, was this created by a government employee in the course of their employment, right? And so like that is the question that you need to answer. So like you should sort of look in and be like, do you think this is created by, like if they're doing like this is a report, then that report may have been created by an employee, it may have been created by a government, like a government employee or a contractor, and that's the question there. Let's try to see if I can find a good example.
There's a really weird case of that, Meredith, that I learned about because I used to work with someone at the Air Force Academy in the United States. The academic employees of the Air Force Academy are federal employees, and therefore you'd think that anything that scholarly articles that they would write and textbooks and so on would be born into the public domain. And that was true until recently, but there was an update to the copyright code quite recently that gives specifically academic faculty at the US service academies get to keep copyright over their pedagogical and scholarly work. So there's an odd exception to that rule, which is quite recent.
Yeah. So there are I'm just looking to see the examples.
Can I ask a follow-up question? So
Sure.
in general, we tell people that if you don't see a CC license, assume it's copyrighted. Is like the reverse true on a government website? Like if it's not clearly copyrighted, you can assume it's public domain?
I think that's generally true, but like I think that's an area where it would be great to have a like more clear explainer. And I just, in order to not like give you an answer, I think the answer to that is like my first hot take is yes, generally that is true, but I would want to go through and like look at a wide enough range of web pages to like really give a good answer on that. So my answer, it's, being a lawyer, it's always slightly complicated, but answer, there's sort of two parts. One is, I think the answer to that is generally yes, that like, stuff that is published by the government in the course of being the government is in the public domain. Stuff made by government employees is. Then the other question I think is one about just sort of pragmatic risk. And for stuff that's like general background information about copyright from the Copyright Office website, the risk of them being like, hey, you can't share this information about copyright is just vanishingly low, right? And so, but I think the answer is there's space for more nuanced explanation here, and I'll take a look and see if I can come up with like a sort of more clear, useful guideline for you and follow up with that. So state employees are not necessarily under the same rules. So states can have their own laws, but generally stuff created by state employees is not automatically in the public domain and the same way stuff created by federal employees is. So there's a couple of questions about AI, which is like, are AI works copyrightable? And are you observing an increase in AI generated content and sort of novel challenges? So the short hot take is that works created solely by AI are not copyrightable, right? Copyright law in the United States and in most other countries requires a human author. And so much like the monkey selfie case, which is a case where like a macaque picked up a camera and took a picture of themselves. And the court said, no, that's not copyrightable because there is no human author. Generally, we say AI created works that is solely AI created does not have a human author. In practice, the Copyright Office, in one case, rejected a work that someone had prompted sort of mini versions of tweaks in like a Mid-Journey photo or Mid-Journey image, and that work was rejected. In another, a woman created a graphic novel where she had written the text and the images were generated through an image generator. And for that one, she was given a copyright in the text, but not in the images. In practice, people use AI tools sort of up and down the level of formality. So certainly, lots of photographers use tools in Photoshop that are functionally the same technical tool as a AI image generator to, remove an unwanted background thing and extend over, or to, extend a texture or a picture in that tool. And we don't look at those and say, like, you can only get the parts that you did not use these AI tools to generate. You can get this photo except for that background piece. Like, no one really does that. And so I think in practice, what we'll see is that works that are created primarily through AI and not significantly altered by people for now are not copyrightable, but that works where if you use, for example, AI to write like a first draft, but then substantially edited it, that those things are going to be copyrightable. In terms of new copyrighted content being created, I think people are using it for lots of stuff to create, sometimes for useful process tools and sometimes to create sort of large volumes of junk. And I don't think we know yet how that's going to work out, right? I think it's creating, I think it's sort of a new version of a moment that happened a long time ago, which is having to understand that everything that you see on the internet is not true, and that you need to use sort of context clues and institutional information to understand things that are and are not true, because you can't just assume that everything on the internet is real or is correct. And I think we're having that moment with AI, that just because you have some like good prose doesn't mean that the thing is in fact a true thing created by a person for a purpose. I don't think we know how the AI is going to change all this. I would say that I think personally that the focus on questions around copyright as the core ethical axis of like, is an AI tool ethical or not, is probably a mistake. And that thinking about questions about access to information and freedom and the ability to have like an open internet in a sort of post-AI era, those things are going to be more important than the sort of copyrighted piece. That's my sort of first intuition. We're doing a series of focus groups and workshops about that. For folks who are interested, I can drop the link to that in the chat, but it also went over the CC listserv. From a legal standpoint, if the person just said they created the AI material, well, technically there'll be penalties for lying in the application, right? If you lie in the application, you've committed fraud, and there could be a penalty for that, and also they can deny your application. In practice, I think what's going to happen is, if what you've created seems normal and you say you created it as a person and not with an AI, that a lot of that's going to get registered, and you will be given a copyright. And the question about whether or not that copyright is valid is one that will be litigated if anyone ever sues for infringement in either direction. In both copyright and patent, there's a decent amount of stuff that sort of filters through the initial registration process, but that isn't ultimately decided there. The registration process in both patent and copyright is a first cut, but in both patent and copyright, you'll regularly see later litigation sort of re-asking the questions that were asked in that registration process. So if you created something that was created with AI, and then you attempt to sue someone else and saying you're infringing my copyright, and they look at that and they go, I don't know, it looks like it was entirely AI created, that'd be a question decided in litigation. And then Jonathan said, what if something comes out of an AI is substantially identical to an existing copyrighted work? I think AI can clearly be used to produce infringing stuff in the same way that many sort of technological reproduction tools can. So it would be a question. The thing to remember, I think, is that infringement is a question about a single existing reference work, not like a body of work. So some of the early questions about AI tools that say like, make me this thing in the style of this artist. You can't infringe a style. So you would have to judge infringement on a specific work. But then I think things produced by AI for infringement would be judged in the same way that things not produced by AI were. Like, does this infringe this work? And that's like a factual question. And the person who's liable for that infringement is the person who created and distributed the thing using the AI tool. So we have a bunch of questions. I answered some of them out of order. Are there any questions in the last 4 minutes? Okay, well, thank you guys so much for coming. The government website one, I think, is good. I think the answer is basically yes. You can assume stuff on government websites is not protected, but I think there's a lot of important stuff there. I'm going to drop my email in the chat. If you have government documents and government website questions that you want to send me, we can work on a more sort of comprehensive version of that.
Thank you so much, Meredith. As always, I learned so much listening to you, and all the thank yous coming in on the chat. People really appreciate you sharing your time with us and expertise. It
Yeah,
is fantastic.
absolutely. Happy to. And please do send me examples of government document public domain questions, because when we build stuff, it's much more useful if it's built on things that people actually have questions about and not us imagining what those questions might be. So please do send any sort of government websites, government documents, questions you have, and we'll work on having a better resource for that in a little while. Thanks all.
Thank you very much.